Good day, ladies and gentlemen. Joy Stephen again, giving you another case law for the Student Herald subscribers. An interesting case about citizenship. The respondent landed in Canada as a permanent resident on October 16, 2007 and applied for Canadian citizenship on July 13, 2011. In his citizenship application, he declared 106 days of absence from Canada during the relevant period October 16, 2007 to July 13, 2011. A citizenship officer reviewed his application, and on May 24, 2013, the officer sent the respondent a residence questionnaire to complete in order to assist in determining whether he met the residency requirements. In the residency questionnaire, the respondent declared that the same absences as in his citizenship application, all except for the last trip to Lebanon in July of 2011, which was omitted after being transferred twice. The file ended up in the hands of the citizenship judge who ultimately made the impugned decision. The citizenship judge noted that the respondent had been given a residence questionnaire and that there had been questions regarding the respondent's credibility because the citizenship officer had had difficulty assessing his residency. He found that the respondent was credible and that there were no inconsistencies or contradictions in his oral or documentary evidence. The sole issue raised in this matter is whether the citizenship judge's determination that the respondent had met the physical presence test set out in the purgatory was reasonable. The respondent asks this court to dismiss the application at the onset and not to consider it on its merits due to the fact that the applicant submitted an affidavit at the leave stage that wrongly attributed a set of handwritten notes in the decision maker. The applicant acknowledges that the notes were attributed to the citizenship judge in error, but submits that the court should exercise its discretion to hear the application on its merit despite this error, since it was not intentional. The authorship of the notes does not substantively affect the applicant's argument that the decision is unreasonable, and the applicant has a strong case. The respondent submits that the applicant's argument is based almost entirely on the absence of re-entry stamps in his passport. But it is well established that passport stamps do not constitute irrefutable evidence of a person's movement across the Canadian border, as not all countries, including Canada, routinely stamp passports at entry. After assessing the documentary and oral evidence, he concluded that there were no inconsistencies in the documents or oral evidence provided by the respondent, and that the respondent was forthright and direct in answering questions and presented as credible. For these reasons, the application for judicial review is allowed, and the matter is to be remitted to another decision maker for redetermination. Another interesting case from the Polinsys Studios. This is Joy signing off. Thank you.